lecture, the title of this lecture is Jurisprudence Towards Cyberneticism. How law and the rigid legal rules transformed and adapted to a feedback system, which is cybernetics and technology. This tour is a comparative. We will move through six legal traditions and 70 years of cybernetic jurisprudence. A human journey, in fact, that started from in the direct aftermath of World War II till this very day. How cybernetics was evolved and integrated into law. So, this is a theme of global cyberneticism that was adapted and embraced by jurisprudence. Jurisprudence in law has broken the cage of traditionalism and rigidism and adapted cyberneticism and with all its technical, rapidly evolving feature. So in this lecture, we will move through this journey, a human journey of 70 years, where jurists, judges, law professors, and lawyers have contributed together. And I don't mean the direct conception of together. Everyone was individual, but when you combine all their contributions, you will establish a portrait, a collaborative portrait of the human march of cyber toward the cyber jurisprudence. Law as a cybernetic system. This was a very challenging, in fact, when and during World War II, technology was heavily adopted, and all fighting powers adopted and exerted very intensive efforts to develop and to achieve milestones and to outpace other rivals and other enemies in the field of technological adoption. So all evolved technologies during World War II have created several and critical legal challenges and global legal challenges due to the global theme of this war. So all of the world nations were affected by this technological evolution and advancements. So in the direct aftermath of the World War II, jurisprudence and scholarships have discovered very explosive gaps and very notable gaps in understanding how will we integrate these technological advancements in our ordinary legal life. How will we codify and organize the legal inevitable impacts of those technologies that were affected during the war and in its direct aftermath? So, the leaps achieved in communications that led to the creation of cyberspace, the first manifestation during the war, have compelled legal philosophy to inquire and ask a very fundamental question: can law itself be designed and managed as an adaptive feedback and control architecture? And in simple words, can law can law carry technological features? Can law govern technology and can organize its impacts in all the stages of its life, from design, manufacture, creation, then deploying, and the impacts of its deploying? This question is divided into three core conceptions. Information. Legal norms operate as institutional signals transmitted outward to society. This establishes parameters of behavior, procedural requirements, and boundaries of action. So this is the first challenge. Can legal norms move from being merely conceptuals and conceptions to have determine to be a determinant and factors and parameters of behavior? Can we establish a determinant of human behavior and social behavior to be integrated and measured, and integrated into a complicated process, so it could be understood, interpreted legally? Then a court or a judge can uh, can give a judgment on this single behavior. This behavior is a technical one because it occurs during a technological sphere and during a technological interaction between human beings. The other challenge and the other conception here is the feedback loop, like compliance, civil obedience, disobedience, and what emerges as in social conflicts loop that back directly to courts and legislators. How in courts judges will be able able to interpret social and ethical behaviors within the sphere of technology. So we have now novel manifestations of human inputs to the judicial process. This that was evolved because of the technical theme of the of the first one of the first human interaction that occurs, the systemic noise, which reflects a side of applying technology and integrating technology into law in this system, cybernetic system, like biases, linguistic ambiguity, and other reg- phenomena caused by applying law into applying technology into human interactions and the ethics created by this adoption. In 1948, Norbert Wiener, and he was the first one to take this issue to the table of scholarships and jurisprudence. He mentions that coining cybernetics as the science of control and communication in animals and machines. This became the universal seed of legal cyberneticism. So the concept of legal cyberneticism is affiliated and attributed originally to Norbert Wiener in the very aftermath of World War II. The United States approach was revolved around two main concepts: ethics and operations. How will we adopt technology and utilize it heavily to achieve our goals, like we did in World War II and defeated our enemies? In the meanwhile, how will we comply with basic and ethics and fundamental human rights? How will we maintain them? The early American school adapted systems approach, as I said, revolved around two main conceptions. Because in World War II, the United States and the Allies and also the Axis powers had heavily utilized technology to win the war and to achieve their objectives. But after the war was ended, all asked, how will we comply with ethics? Technology is indispensable. Sorry, we must use technology, but how we comply with fundamentals of justice and fundamentals of human rights? Norbert Wiener, as the founding of the science of legal cybernetics, warned that automating legal systems and the blind, enthusiastic one would risk creating closed and cold loops. He emphasized that technical design carries deep moral and legal responsibility that all systems should comply with. He required, therefore, independent channels for human audit and appeal, and this was the first manifestation of the concept of human in the loop, and this is a critical governing conception in utilizing technology, in particularly artificial intelligence. Then came Philip Zelznick, adopting the concept of responsive law. He modeled legal institutions as living, adapting social organisms, rather than viewing law as static statutes and legal texts. He argued that law relies on systemic feedback, so his approach was more dynamic than Weiner. He called for organizational learning and social adaptation to remain the legitimacy of adopting technology. So here we moved a little towards the idea of the rule of law in the technological environments and technological spheres. So we have moved from the static view of Weiner to the a dynamic model of responsive law. After him came Dolin with the concept of instrumentation and metrics. He said that the operational legal value through a rigorous cybernetic equation, quality, and cost. So he tried to adapt a direct quotation of technology and law, quality and cost. So he integrated performance metrics direct to the concept of adapting law into technology. So it is something like a practical view, practical concept. So while Weiner was static founding one, and Philip adopted a dynamic responsive view of the dilemma, Dolin adapted a practical scientific one that he saw only applying equitation into law, into social and legal norms, and govern it through its outputs. And this is the first of the six traditions during our journey. Then came Arun. Arun was American, also philosopher, but he was anti-capitalism. Arun, an American philosopher, he adopted an anti-capitalist approach regarding how we adapt technology into law, or how we integrate technology into law. Harun, Harun visioned that the capture of sensing mechanism. Anjali Arun introduced a sharp political economic critique to legal cybernetics. She argues that the monopolistic tech giants, which has started to appear in the 1960s, have successfully captured the legal system sensing mechanism. She warned against capitalism, and she thought that capitalist internet giants would control how legal thinkers, jurists, and judicial policies will be drafted in this field. So she said that the effect and the powerful impacts and the powerful grip of internet giants will prevent judges and scholars and jurists from creating impartial systems of legal compliance regarding uh, adapting technology into law. In other words, capitalism will govern everything and will prevent law from achieving its pure objectives, which aim at the good for humanity. She, she assured that through lobbying, industry-led standards, and private technical imitation, corporations will embed their economic priorities and dominance and the technology dominance objectives directly onto the code of legal norms. So they will filter out the corrective feedback from marginalized and affected communities. So this was the first warning of bias, what we call now bias in the technological aspect. We now warned from bias.
Your mic is muted, so Yassin.
It was open, in fact. That I don't, okay, it is open now.
Yes.
It was open already. Okay.
No, it went.
Okay, we are at Arun now. You heard me about her critique, anti-capitalist.
Yes, the critique. Most of it we heard, I think, were in the prescription.
Yeah.
Okay. In other words, and in simple words, Arun warned it that internet giants and capitalist corporations and standard industrialists would create and enforce their industrial standards and private technical mediation to prioritize their economic goals rather than the pure application of the code of law. In the same time, they will filter out corrective feedback from marginalized and affected communities. So, and I repeat here again, this was the first warning of the phenomenon of bias. We are always warning from bias, and all AI scholarships and all knowledge about technology and AI say beware of bias. But honestly, Anjali Arun was the first one to warn from bias. She saw bias as a capitalist industrial one, so he is economic bias. So she drafted a prescription to avoid this state of the art and to avoid this bias. She suggested transnational legal harmonization as a global collaborative contributions, as I love to say always, to enact coordinated global frameworks on technical transparency and accountability to bypass state jurisdiction silos. Although she adopted shared enforcement networks by collaborative international oversight bodies that block regulatory circumvention by multinational technical monopolies. Also, distributed sensing about technology and AI say beware of bias. But honestly, Anjali Arun was the first one to warn from bias. She saw bias as a capitalist industrial one, so he is economic bias. So she drafted a prescription to avoid this state of the art and to avoid this bias. She suggested transnational legal harmonization as a global collaborative contributions, as I love to say always, to enact coordinated global frameworks on technical transparency and accountability to bypass state jurisdiction silos. Although she adopted shared enforcement networks by collaborative international oversight bodies that block regulatory circumvention by multinational technical monopolies. Also distributed sensing architecture by working on the system itself, system sensing power directly, It should be a redistributed one to civil society legal practitioners. And I say again, this is another manifestation to the concept of human in the loop, but she said to be, and she preferred to be a global collaborative human in the loop. And this is the view of Anjali Aron. She's American, but was anti-capitalist critique. And the second tradition of our journey is the Italian approach. And honestly, the Italian approach is older than the American one. And it is divided into four main jurisprudential concepts. So, and each one we will see, we will was adopted by a philosopher or a judge. Idealism. Vittorio Frosini. He viewed cybernetic technology as a comprehensive social ideology. He argued that the digital revolution shapes all human relationships, fundamentally altering legal interactions. So he, in simple words, said technology will take the dominance over law. In in simple words. Then came Mario Lozano, who adopted positivism. He said that established jury in Europe, just like the American philosopher Return Dolin, just like Dolin. He also created jury. It's something like equitations, like transforming, norms, pure norms, legal social norms into numeric values that could help to measure the severity of a human behavior. He analyzed quantitative legal data set to empirically map cybernetics' impact on statutory and judicial environments as a reflection of human social life. The third Italian scholar was Lombardi Valori. He adopted an axiologist approach by arguing that algorithms can model the brain's rational function but can never replicate the moral essence of judgment. He warned against losing the human value depth and he stipulated in his view that any adoption of technology must comply with ethics and the fundamentals of human justice and human good. So he reflects axiology in his view. A little unlike him, in fact, Renato Prosso, and in, this contrast came from that Prosso was a judge, and when you work as a judge, sometimes you differ from scholars and from jurists. You know this difference between what you think to be and what is already happening. So always judges you will find in their works, in their writings, in any research or book by judge, you will find a sense of practicality, practictionalism. You will find the reflection of what already happens in the real world litigations into their book. So Justice Renato Barroso adopted a pragmatist approach regarding our issue. He directly designed and engineered the Itagure Find platform. And it is something like a case law database, like we say now, case law database, searchable database. He treated legal documents as a structured data set for retrieval, rejecting automatic decision. So here, his work and his profession as a judge led him to create a practical solution and a practical mechanism to utilize technology into the judicial work. He was the first one to say that court judgments, all information included within legal documents, should be the database of any adoption of technology into law. So here the Italian approach, in conclusion, are four lenses, and honestly, I call them the four founding of legal cybernetics. Despite the fact that Norbert and Weiner was the first one to found legal cybernetics as an independent branch of knowledge, I say that the Italian contributions, in fact, through these four conceptions, jurisprudential conception, it was the core momentum human of human march towards adopting technology into jurisprudence and law. The third tradition and the third phase of our journey was Germany. In Germany, scholars have introduced the concept of Recht Kybernetik, and it means legal cybernetics in English. The German school produced the most rigorous systemic theories of legal cybernetics. They modeled the law as an self-evolving social communication loop, and this is the distinctive feature of the German school and the German jurisprudence. First, Vincent Rodick, he adopted dynamism. He constructed mathematical flowchart algorithms that represent legal systems, where statutes serve as input signals and public compliance forms continuous systemic feedback. Then came Albert Achtenberg, who adopted a state-centric approach. He argued that state rules function as control mechanisms to steer society. Then he insisted that technological automation must be subordinate to democratic constitutional bounds, meaning that as the state regulate laws to control and to organize human interactions in the real life, state should innovate laws and suitable laws to organize and enforce the rule of law in all technological environments with compliance to the essentials of democratic societies. Then came Nicholas Lohmann by the concept of autobasis. He defined law as a closed, self-referential system. So the system self-reproduces recursively through its binary code, legal, illegal. A binary code that govern human interactions in in technological environments. That code should be closed with no intervention of external interventions. So the code filters out direct societal noises. So here we are working on a closed loop system. Rudolf Paul, he adopted epistematics. Sorry, he advocated for reflexive governance frameworks by combining rigorous technological safeguards with normative human values to prevent reductionism. In this lecture, I know we might suffer from conceptions or some complicated one because it is, I know, as you know, it is jurisprudence. It is the nature of jurisprudence in itself. It is a complicated sphere of law and aspect of law. But when you delve into it, and when you, I don't want to say control it, but when you manage to understand how jurisprudence works, you will find yourself that you can design what will come in the field of law. What you will be able to lay the conceptuals of the upcoming events of law globally. Cyber jurisprudence is a global one, is a global field of knowledge. So when you tackle it and when you tackle its fundamentals with its difficult and hard conceptions, you will be able to delve into and to control any matter in the field of cyber law. So I would like to apologize for this hard conceptions, in fact, and I will try to simplify it as much as I can. Okay, ready now for the to move to Asia? If you are still with me, just let me know.
Yeah, we are here. Everybody's
Yeah,
listening
sure,
attentively, I guess.
sure.
Okay, in Asia, ontology has met with practice. We have two scholars in Asia who had introduced a very heavyweight contribution in this jurisprudential field. The first one, Yuk Hoi, and I think I am reading the name right, from Hong Kong, he constructs a deep ontological philosophy of cybernetic systems and highlights their inherent recursivity, where outputs continually return to modify internal state roots. So he in this case adopts the concept of recursivity. Law and the relation between law and technology will never die, will never reach and stand still, because the outputs ongoingly affects the internal state rules. So, state rules here and the governing rules in cyberspace and technological environments are in a state of ongoingly and continually developing. They are because of the effect of outputs, the ontological effects of outputs. Under his framework, digital networks and automated legal technological tools are not external instruments. They are artificial organs, like the organs in human bodies, that structurally mediate human perceptions and legal logic. Therefore, system agency is distributed dynamically across human-machine networks. From the other hand, from China, Wei Dongji has studied the massive cybernetic implementation of smart courts and AI systems within China's judicial system and analyzed automated trial visualizations and case matching system. However, he presented a critical warning. This warning revolves around that automated predictions must serve to inform and to co-evolve alongside judicial discretion. Never replace a human with a machine. Okay, this is the brief of G's warning. So here another application of the concept of human in the loop, but he here and sorry, his view here was very narrow on the concept of human discretion, the judicial discretion. So at court, judges must not only apply equitations, algorithms, no, they after they apply the the automated system or the automated method, he must apply, or sorry, he or her or she must apply the pure human discretion to measure and to think again about the final judgment and the output of the technical automated system. So here Asia have two lenses, and honestly very heavyweighting one. The recursivity of Hoy, which means that law never dies and law never reach a standstill regarding technology in the face of technology. And Jews in China who was affected by the China's approach to technological dominance and heavy utilizations of AI and smart cores in China. So this Chinese nationalists national approach incentivized G to warn and to shed light on the importance and indispensability of human judicial discretion. As I said, never replace a human with a machine. In Egypt, 2 years ago, I wrote a paper, a research paper, and it was published in Germany by Springer Nature. Its title was Introduction to Cyber Jurisprudence, where I managed to to introduce cyber jurisprudence as an independent branch of legal knowledge, independent from cyber law. I established in this research judicial cybernetics as a simultaneously descriptive and prescriptive science, redesigning courts' procedures as unified, self-regulating feedback architectures. The first conception, in my view, which was published in this research, descriptive access, rigorous scientific modeling of existing cyber jurisprudence, procedure decisions, and digital evidence standards to reveal emergent self-organizing trends across global judicial system. The second conception, prescriptive access, iterative feedback-driven statutory interpretation that views historic case outcomes as system outputs and introduce flexible, recalibratable judicial standards that evolve in the real time to adapt and to contain the rapidly evolving technological advancements. Number three, the procedural design, engineering practical courtroom safeguards, and specialized chain of custody for dynamic digital evidence, neutral technical assessors, and transparent logical reasoning templates for judges' AI loops. So, this framework I introduced in my research then, its normative core mandates a dialogic architecture where human judges, technical engineers, and civil society actively co-create system parameters, rejecting pure closed technological rule. And from then, I extracted the concept of global collaborative contributions, which CyJurII was established upon a year after. So, we have now moved through six traditions, which are gathered by one cybernetic lens. In this table, I summarized the journey toward this legal cybernetics. While all six legal traditions conceptualize law as a self-regulating feedback and control system, each focuses its regulatory steering on a unique node within the cybernetic architecture. I think I don't need to repeat them, but you may look at this table: USA, operational and political economic; Italy, Germany, Asia, Egypt. This table summarizes the journey. We have now reached the end of this presentation, and we would like to say a word about CyJurII research because I published this article at CyJurII Research, and it was published in the yearbook of 2025 that aims from static rules to a living self-steering system. This is how we see legal cybernetics at CyJurII. Cybernetics provides legal theory with a dynamic vocabulary, transforming law from a static list of written statutes into a living, representative mechanism and creatures. The challenge of this era is not to replace the rule of law with automatic machine steerings and algorithms, but in contrast to build a more resilient, transparent, and fair legal architecture using cybernetic thinking. And this is the core mission of the research department at CyJurII. Thank you again for listening to me for this sophisticated and complicated topic. I tried to simplify it as much as I can. Okay, I will close now my sharing my screen.